shall pass. And you see that historically, outbreaks have progressed in terms of the recovery over a period of months, not years. And so that's encouraging, but I think it all just comes down to getting the virus under control and being able to get at least back towards some level of normality. We've done a good job. So you can see these were the projections on the medical side at the end of March, where, we weren't going to exceed our full hospital capacity, but we weren't looking too great in terms of ICU beds or ventilator demand, where we were just going to be basically right up against our capacity to be able to offer those services. Here's a projection from last week that shows that we have done a good job of flattening the curve. And instead of getting back towards something that looks like normal in maybe early to mid-June, we might be able to see something that's manageable by mid-May. But again, this is really what underlies all of the uncertainty in those economic forecasts that I showed you. And that's the part that we're not equipped to deal well with. But, you can see that going hard early works. When you look at other countries, Hong Kong is doing pretty well. Singapore had this huge, spike because they, again, didn't do the go hard early approach. So that really does work. And, the thing I'm worried about is that we try and rush back out too early, get cabin fever. Believe me, I'm struggling myself, but the numbers are pretty astonishing. If you just rush out too quick, you can get that tenfold increase in the number of cases. And that's a much different prospect for the recovery, right? Going into a temporary shutdown mode for a month or two is one thing that maybe with some government assistance, the businesses can battle back and bring their employees back online. But if we're still having virtually no economic activity in September, October, November, December, that's a much different story. Not a lot of businesses are going to be able to survive that long, no matter how much assistance we pump in. So let's stay at home and get this thing buttoned up, because I think if we can do that, it can maybe look something that looks more like a Hurricane Katrina than it does like a 2008 financial crisis, right? Where we had this spike virtually overnight in negative economic impacts that we're then able to chip away at over the course of 6 to 9 months and get back to normal as we kind of get into a recovery mode. So I think that, for me, it all boils down to the fact that, yes, we were in really good economic shape going into this thing. This is not a 2008 where we had terrible fundamentals. But that being said, we need to hunker down because we're in for a couple months at least of belt tightening, even though the data is still rolling in. I showed you both in terms of the member surveys and what realtors are seeing out there on the ground, but also in the MLS data where we're seeing the listings and, more importantly, the closed sales down by double digits in virtually every major market across the state. We're going to see those negative impacts, right? It's just it's going to be a tough couple of months that I think will persist, at least for the closings in April and likely into May and maybe even June, based on where the pendings are right now. And so the key is to get the outbreak under control so that we can get back to at least somewhat of a recovery mode. And so, the tighter we can lock it down right now, I think might just be just what the doctor ordered to make the recovery that much more robust. So C.A.R. is doing a great job, and I'm proud to work there because of all the stuff Gov and his team are doing, and everybody else. It's been a crazy time, but they have the staff at C.A.R. has really stepped up to the plate. So here's the link with all the resources that are out there for you. And I say thanks to Laura for having me, and yeah, we'll get through this together.
All right, Jordan, I got a couple questions.
Great.
First of all, your slides will I be able to share them with everybody?
You'll be able to share them. I'll send them to you as soon as I
Okay.
sign off here. So hopefully you'll have them in your inbox before the thing even ends. And you can also download them from this link here on the C.A.R. site. And that might take a little bit longer for them to get up there, but you'll have
Okay.
them.
Okay, and then I'll put that on our education page for our members so that they know where to go and get it. So I have two questions for you.
Okay.
The first one is, can you explain how the GDP relates to us?
Yeah, so GDP is just this like fancy, nerdy, esoteric term for income, right? It's basically the amount of income that either businesses or individuals are earning, and they go through and add all that up across the various sectors, and that's this kind of number called the size of our economy. But really what GDP is just measuring how much money is pouring into people's bank accounts and into the business revenue side of the ledger. And so, when we see GDP going down, that's just telling us that businesses aren't making money and that people are being laid off. And I think that, again, that's why I tend to look at the unemployment numbers, because it's more tangible and easy to understand. It's just a translation of that GDP stuff, but basically it means that fewer people are able to work and earn income.
Okay. And then can you speak to your C.A.R. graph?
Oh, the SARS graph?
Yeah.
Yeah. So if you go back and look at some of those charts on SARS and on MERS, they were down. Like in the MERS outbreak in 2015, we had negative economic impacts where the market only, was down basically about 40-ish%. It stayed down for a period of about 3 to 4 months, but then it started to generally improve in the fall. So that was just to kind of show you that, there's these big dramatic hits to the economy, but then things start to gradually improve. And, once you get 6 to 8 months down the road, things were essentially back to where they were. It wasn't a 3-4 year recovery process like we had during the financial crisis. That was my main takeaway there.
Okay. And SARS was a different virus, right?
Yep, totally different virus. And MERS also was a different virus. This is just kind of, again, we've never seen anything like this. And so what we do as data nerds and economists is try and go back and find some kind of a historical analog, even albeit imperfect ones, to try and guide our thinking that we could use to like extrapolate to what we're seeing right now.
Okay, I have one last question for you.
Great.
If the curve can flatten in May, which is in 1 month, why should we lock down 2 months instead of 1? Do you have the number or a curve run for 1 month instead of 2?
Well, this was 2 months. Actually, if you go back to this is like 2 months from when we started in early March, so, or in mid-March. So that would line up with that. I'm trying to pull these every week, but it's just more of a kind of demonstration on how sheltering in place works. I leave it to the experts to decide what that time cutoff is, but the important thing is just to get it behind us so that we can start to resume economic activity. That was my big point on that one.
Okay. Thank you very much.
Hey, thank you guys so much. I'm going to let Gov do his thing, but I'll send these slides right over.
Okay.
Thank you, Jordan. Next up, we have Gov Hutchinson. Gov is Assistant General Counsel, Vice President of the California Association of Realtors. Gov has been with C.A.R. since 1985 and manages C.A.R.'s member legal services program in Los Angeles, and Gov advises realtors through the hotline on all aspects of real estate law, and trains and supervises other hotline attorneys. He's a priceless component for our risk management committee meetings. Gov received his bachelor's degree in history from Princeton University and his Juris Doctorate from the University of Pennsylvania. He has written for California Real Estate Magazine, co-authored C.A.R.'s continuing education courses, and is a master instructor for the education division of C.A.R. with certification from the Department of Real Estate. He also regularly speaks to associations, boards of realtors, affiliated trade associations, city and county bar associations, and major real estate firms. It's all yours, Gov. Thank you.
Good to be here, everybody. Talking to people. I think I might be talking to people from 4 different counties right now, which is interesting. I'll tell you why that's interesting in a second. So first thing I want to talk about is, remember, the real estate is considered an essential service. It means you guys, unlike some people, can actually work. But that doesn't mean it's business as usual, as you probably know. The state of California basically about a month ago issued a rule saying, yes, your real estate is essential, but you have to follow certain guidelines to be legal. And these guidelines are basically meaning you have to follow all the health orders and the CDC guidelines. So to make it easy for you, we turned this into something called best practices. So we got this best practices guide that basically tells you what you can do and can't do. And to make it really easy for you, we've turned these best practices into a couple of forms. So I'm going to talk about these forms. If you use these forms and do what these forms say, you are definitely okay. You're following the law. You won't get sued. The seller and the buyer are indemnifying you if you do get sued, and your errors and omissions will cover you. If you don't follow these rules, E&O won't cover you. Your clients don't have to indemnify you, and you might get sued, and you can even get cited for misdemeanors. So it's very important to follow these rules, which is why we have these forms. Now, of course, the state says what you can do, but some counties and cities are being even stricter than that. The good news is Orange County, Riverside, San Bernardino County pretty much adopted the state rules. But up until a couple days ago, LA County was stricter. LA County said up until Friday that you guys can only show in person vacant properties. If the seller still lived there, you couldn't do it. Well, that just changed. So in LA County, you can now show properties even though they're not vacant. But here's the catch. The people that live there got to temporarily leave while you're showing it. Now in Riverside, Orange, and San Bernardino County, it doesn't say that. So the sellers can actually be present, or the tenant can be present when you show it. LA County, though, I think it's a good idea everywhere, but they should be gone. They have to be gone when you actually show the property in person. I mean, ideally, you do things virtually as much as you can. But if virtual isn't possible, then you got to do, and you got to do it. You have the ability to do it with the restriction in LA County that the seller or the tenant has to be not temporarily gone while you do it. So let me talk about these forms for a second. The first form I want to talk about is it's a coronavirus listing addendum. In other words, if I were you, I would anytime I took a listing, I would make the seller sign this addendum called the RLA CAA. And what this form says is the seller is promising that they're going to follow safe practices. You know what that means? If someone's going to come in the property, that means one agent and two buyers maximum. And the two buyers have to be related. You can't have two unrelated buyers. If you're going to have two buyers, they got to be related in the same house. They can't bring their kids or anything like that. Plus, everyone's got to wear a mask. Everyone's got to wear gloves. You're not supposed to touch anything. You're supposed to keep 6 feet apart. By the sellers, when they sign this addendum, they agree that they're going to go along with this. So you know what that means in LA County? That means they agree they're going to leave the property during the showing. So everyone's agreeing to this. Seller's promising to agree to this. The realtors are promising to agree to this. The seller agrees after each showing, they're going to disinfect, whatever that means. I mean, if everyone's wearing gloves and they don't touch anything and wearing a mask, you probably just have to wipe down the doorknobs or whatever. But the point is, the seller is promising after each listing that they're going to clean and disinfect. It also means that the seller is going to require every buyer, buyer's agent, inspector, photographer, anyone who enters the property is going to sign the second form called the PEAD, the Property Entry Advisory and Declaration. On this form, everyone is signed, the buyers or the agents are saying, when we enter the property, we're going to follow the safe practices. We're going to follow the best practices. We're going to follow the protocols. We're promised to do all these things. And also, by the way, everyone signs the second form. So the first form, the RLA CAA, that's signed by the seller and the listing agent. And by the way, you know what else that form says? That form says the seller and the listing agent decide which marketing activities are we going to do and which ones are we not going to do. Because in this day and age, maybe, you know, it's not clear that they can do staging. Staging is not exempt like this. Or you're going to put up a sign, you're going to do this, you're going to do that. You're going to decide right on this form. Also on this form, the seller's going to decide, do they want a home inspection? Are they going to allow this inspection, this inspection? Yes, under the rules, inspections are okay. But what if you're dealing with a seller who says, I don't care what the rules are, I'm uncomfortable with people coming on my property, I'm going to keep it down to the minimum, I don't want any inspectors. Or appraisers. Of course, if you don't have inspectors or appraisers, that may interfere with the buyer's ability to buy it, and it may interfere with the seller's ability to sell it. So there's good disclaimer language on the form that says, seller, if you don't allow certain things, that you're going against, you know, you're that may affect the value of the property, the sales price, that may affect your ability to sell it, and the seller is agreeing to that. The
Can I
sellers,
ask you a question
yes,
about that? Okay.
sure,
So the RLA addendum,
yes.
does it have a time frame on it when it may not be used any longer?
Well, remember, it's an addendum to the listing, so it lasts as long as the listing does.
Okay.
So it's part of the listing. So bottom line, as I said, as your lawyer, the reason I like this form is because it protects you from lawsuits, protects your E&O. The seller and buyer have to indemnify you. If you get sued, they have to indemnify you. So it's all sorts of good things there. By the way, a lot of the things I'm talking about can be done remotely now, like appraisers. They've loosened the requirements. But inspectors, obviously, people have to go there. What about notaries? Right now, you can't do virtual notaries unless you use a notary from another state, if that state allows virtual notaries and your lender and your county recorder are okay with that. And our experience is generally they are okay with that. Okay. One more thing on this form. The broker says, I'm going to do the best I can, but it's not up to me to verify that everything the buyers say before they enter is true. I don't know if they're telling the truth or not. And then also, the seller says, I can't prevent people from violating the rules. If someone's going to come into the property without wearing a mask or gloves or something, I'm not going to physically throw my body in front of them to stop them from coming in. So that's a good form. The second form that I mentioned, the PEAD, remember this, everyone's going to sign this. The sellers are going to sign it, the listing agent are going to sign it, the buyer's agent, anyone who enters the property is going to sign this form. It protects everyone. Everyone is promising they're going to follow the rules. You know what else everyone is promising? Everyone is promising when they sign this form that they're not sick as far as they know, they have no symptoms, and they haven't been in contact with anyone that they know is sick in the last 14 days. But it also says to protect the agents and the sellers that, you know, seller acknowledges some buyers aren't going to tell the truth, or some buyers don't even know if they're sick. And that's the risk that people run when they move around and go into properties. You never know who's telling the truth, or people don't have symptoms or whatever. And the point is that's accepted and understood. Everyone's assuming the risk, okay? So everyone is signing this form saying they're going to follow the proper procedures, and they're also declaring about their health situation and their contacts. People ask me, does a seller have to sign this every time there's a showing? No. But if the same buyer comes back twice, you want them to sign it each time. Anytime someone enters, they need to sign. Do you need the broker to sign this? No, the agent can initial on behalf of the broker, just like you sign a listing on behalf of the broker, okay? And the form just got tweaked last week, so that's a little bit clearer now. These forms originally came out about 2 weeks ago, and then they got updated a little bit and came out Friday in an updated version. You'll see it makes more sense. It has more disclaimers. It talks about agents can sign on behalf of brokers, or that may not be into the form until today or something like that. But it's a really important form. People ask me, is this a mandatory form? No, these forms aren't mandatory, but the best practices are mandatory. And these forms turn the best practices into a form. So it's easy to say, if you're following the form, you're clearly following the best practices, you're clearly legal. So that's why these are the two real important forms, the listing addendum and the PEAD for buyers and anyone else on the buyer's side to sign. Yes, Laura.
Okay. Is it a good idea to put the PEAD in the supplements of MLS for each listing?
I think that's a great idea because, you know, people can print them out, sign them already. It's not even a bad idea to just print out a bunch of copies. If someone shows up without one, you can sort of give it to them and make them sign it. Remember,
I got one more.
Yes.
For an agent that's showing multiple properties, can all addresses be on one disclosure?
From the seller's perspective, theoretically, yes, but you want a separate buyer signature on each time they enter, each individual property. By the way, someone asked me real quick, you know, if I had the old form signed before, should I sign the new one? Well, from the seller's side, you don't need to. But okay, if you're already in a listing and your seller has signed the RLA CAA, obviously you can't force a seller to sign the new one if they've already signed the old one. The reason the new one's slightly better, it just has slightly better disclaimer language. So if you can persuade the seller to sign the updated one, that's a good thing. If you can't, it's not that big of a deal. If you're on the, as far as the PEAD is concerned, if your seller's already signed it, that's good. But remember, buyers should sign it each time. So the fact that a buyer already signed the old one doesn't help you, because the next time they come in, they need to sign the new one. But if your buyer has already been in there, already signed the PEAD, and they're not coming back, no, you don't need to go get them to sign the new one. By the way, today, there's a new form that came out called the PEAD LR. So people ask me, if I got a lease listing or I'm a property manager and prospective tenants are coming in to the property, so it's not a situation of people buying a property, it's a situation of people leasing a property, what form do I use? Well, up until today, I would have said, use the PEAD form I just mentioned. I mean, it talks about sales, but you could use it for rentals. But the good news is, effective today on Zip Form, there's actually a form specifically for tenants and landlords and property managers, the PEAD LR, lease rental. So that's good that you got a form just for you, just for rentals, okay? Let me talk about a couple other forms real quick. Let's say you're in a contract, right? And in this day now, things sometimes take longer than normal, right? It may take time to get an appraisal, time to get an inspector. Some places there's a court order where it's really, you can't even do it, not where you are, thankfully. Lenders are sometimes taking more longer than normal. Appraisers are taking longer than normal. So there are delays. I think it's a good idea to anticipate these delays. We got this form called the CVA, the Coronavirus Addendum. Sorry, City of Corona, that's the name of the form. The Coronavirus Addendum. And this form, if I'm a buyer and seller, they sign this form, they basically say, okay, if once we're in escrow, something gets delayed because of lender, appraiser, inspector, court, shelter in place, quarantine, I get sick, I lose my job, something happens that's going to mean I can't perform on time or I can't perform at all. On this form, the buyer and seller are agreeing, if something like this happens, we agree automatically there's going to be an extension, maybe 30 days, whatever you want to put in there. So it's like you're anticipating the problem. So when the problem happens, as it's happening a lot, these escrows, you don't have to go back and renegotiate an extension. You've already agreed to it. We also have one just for rentals too. So how would this work? Well, if you're in a lease situation and the tenant, they've signed the lease, but they haven't moved in yet, and then something happens sickness-wise, they got to take care of someone, there's a delay for this or this, so it's going to delay their time to occupy, or maybe something happened on the landlord's side, it's going to delay their ability to make the property available. On this brand new form that just came out today, the CARLA, the Coronavirus Addendum for Lease Rentals, both sides can agree up front automatically to an extension of the time of occupancy. Getting back to the first one on sales, the CVR, the way it works is you can say, well, if this happens, the buyer's deadline to remove their contingencies is delayed. Or if this happens, the deadline to close is delayed. And the parties can agree up front. Well, if there's a delay on the buyer's side, they can delay their removal of contingencies. And then you can check a box. What happens even after the extension? They still can't remove their contingencies. Well, then it says the buyer can cancel the deal, or the seller can cancel the deal with or without a notice to perform, and the buyer gets their money back. Well, let's say the other scenario is they remove their contingencies, but it's going to be difficult to close on time. Then the form says, well, after the extension, of course, as realtors, you can always negotiate another extension, but according to this form, after the extension, buyer and seller agree that if they can't close even after the extension, either side can cancel the deal. But then you have to check a box. Does the buyer get their deposit back, or does the buyer not get their deposit back? I know what you're thinking. Sellers are going to want the box that says they keep the buyer's deposit. The buyers are going to want the box that says they get their money back. Well, what if they can't agree? Well, maybe they won't be able to sign the form. This is not a mandatory form. It's just a form that might be helpful to you in this situation. One more form that goes with this is the NUCC, Notice of Unforeseen Coronavirus Circumstance. I'm the buyer, you're the seller. Turns out I do have a health issue, so I'm not going to be able to close on time, or the appraiser's late or the inspector's late. I'm going to use this form to notify the seller. Well, you know, we anticipated this and now it happened. And once I send you this form, that triggers the automatic extension that we already agreed to. By the way, there's the same form effective today available for you for lease rentals. It's the NUCC-LR. So once again, they're the four basic forms, the RLA-CA, the listing addendum, and you can use that on a lease listing or a regular listing. Then there's the PEAD, the property entry advisory declaration. We got one for sales and one for rentals. We got the coronavirus addendum for sales and the new CVR LR for rentals. And we got the NUCC, the Notice of Unforeseen Coronavirus Circumstance, also for sales and effective today, one for rentals. Another question real quick. What happens if we don't sign the CVR form and the buyer, they remove their contingencies and then all of a sudden they lose their job or something like that happens, or they get sick or something and they can't close? So you didn't use the form, buyer can't close, they cancel the deal after removing their contingencies. Does the seller keep their money or does the buyer get their money back? What's the court going to say? Well, there's in the Civil Code of California, it says, it's called the Act of God clause. If something happens, it's called irresistible superhuman cause that prevents your ability to perform a contract you've agreed to, you are excused from performance and you get your money back. So if the buyer loses their job because of COVID-19, will they get their deposit back even if they didn't sign this form? I'm guessing probably yes. So I think it's a good idea to sign the form so you can sort of put it in writing specifically as opposed to just letting the courts decide. Because I know what some courts are going to say, yeah, the buyer lost their job, they get their money back. But what if the buyer says, I didn't lose my job, but I'm worried about losing my job because of COVID-19? Is that a legitimate reason to cancel? What if you don't use this form? What's the court going to say? That's a grayer area. I'm not sure if a court's going to say that's okay or not. That's why we recommend using the form if you can. Okay, real quick to wrap this up, a couple more things. There are two more forms, and that'll be all the forms. And that is, did you know in California right now, there's an eviction moratorium, which means if you can't pay your rent because of COVID-19, the landlord cannot evict you for 2 months, but you still got to pay the rent back. Okay, so there's one form we have called the NTAP, the Notice to Tenant About Ability to Pay Rent. This is the form where the landlord says to the tenant, well, I noticed you didn't pay your rent. You may have heard there's an eviction moratorium, but you still got to pay me back. You still have to prove to me why you can't pay the rent. And then, of course, you still have to pay it back eventually, which leads to the last form, the RPD, the Rent Payment Delay. This is the form where the tenant sends to you, you know, yep, I can't pay the rent because of COVID-19. I lost my job, I got sick, whatever. Here's the proof that it happened. I'm not going to be able to pay you rent for 2 months or whatever. I'm paying you half a month. And then right on the form, the tenant and the landlord can agree to a repayment plan. Now, to really complicate your life, some of you may live in cities that have passed their own rules. You know what some cities like LA has done? LA says the tenant doesn't have to pay their rent back for like a year. Other cities have had rent freezes where the landlord can't increase the rent for a certain period of time. So not only is there this basic eviction moratorium throughout the state, some cities have put in their own rules on how long do you have to pay it back, and can the landlord raise the rent right now? So you have to check your city. How do I know this? Well, we have a good thing on our website called the Eviction Moratorium Schedule. You can look it up and it'll show you what city and what the rules are in that city. Just like we have another thing on the website, which has all the local ordinances on the safe practices that I talked about. You know how in some cities you only can show vacant houses, not you anymore, thankfully. But you can see what the rule is in your county or your city for that too. Speaking of websites, CAR.org is your standard website, but now there's a new special website, CAR.org/coronavirus, which has everything I've been talking about today. You can look that up. Call my guys, call the legal hotline. They can help you with all this stuff. A couple more things real quick. Remember I said there's a 2-month eviction moratorium? Then the courts announced we're closed till August for unlawful detainers. So even if you're allowed to evict, even if someone has a reason they're not paying rent for some other reason, they have no hardship, they haven't lost their job, they just don't want to pay their rent, you still can't evict them in California right now until August 1st. Now we're hoping that may open sooner, but right now the court says we're closed for evictions till August 1st. They're also closed for a lot of lawsuits. They're closed even for, here's good news for all you potential criminals out there. If you commit a misdemeanor right now, there's no bail. If you're ever going to commit a crime, now's a good time, okay? Just kidding. Another thing that's going on is, let's say you're paying a mortgage. If your mortgage is held by Fannie or Freddie or FHA or VA, it's either serviced or guaranteed or held by the federal government, as a lot of your conforming loans are, there's a 3-month foreclosure forbearance. They can't foreclose on you for the next 3 months, and you don't even have to make the payments. You can put the payments add to the end of the to the end of the mortgage schedule. Now, this is not all loans, but it's some loans. What if you have a non-conforming loan directly with a lender? Well, there's another one that lasts to the middle of June, no foreclosures, but that's not a forbearance. So if you don't pay 3 months from now, or in the middle of June, actually 2 months from now, when that's over, they can immediately demand you pay everything you didn't pay, or they can foreclose on you. Whereas if it's one of these federal loans, it's not just a delay in the foreclosures, it's a forbearance, so they can tack on the payments to the end. So that's complicated. Do I have any good news for you? Yes, if you're doing a 1031 exchange and your deadline is coming up to identify a new property or to close on the new property, that's been extended till July 15th. If your DRE license renewal is coming up, it's automatically extended to July 14th. And appraisals are pretty much relaxed now. If you're doing a refi, the appraisal doesn't have to be done till 120 days after the close. And the very last thing to mention, without going into detail, because I'm not the expert, there are realtor relief programs that you're eligible for. Not today, but a week from tomorrow, on the 28th of April, you'll all be able to apply for something called pandemic unemployment insurance. Usually independent contractors do not get unemployment. This is different. You independent contractors can get unemployment. 39 weeks of it, $600 a week, basically. You have to fill out a form and everything, but it should be a good thing. The point is, it's not available yet. And if you have questions, let me give you a phone number. We have a COVID relief hotline, 213-351-8450. They know everything about this. They know also everything about these small business administration loans you can apply for. Unfortunately, you may have heard they ran out of money, but as soon as the money's coming back, which should be this week, you'll be, if you don't want to get the unemployment insurance, there may be a different thing that may be better for you. You might be eligible for a $10,000 grant. You might be eligible for a forgivable loan. It's going to depend on your income last year compared to this year, et cetera, et cetera. Call that number I just gave you. They have all the details. Or go to that website I just gave you. They have all the details. Do we have any time for more questions?
We have a few questions, yeah. Can you repeat that phone number again?
213-351-8450. 213-351-8450. And of course, you know my hotline, 213-739-8282. If you call the wrong hotline by mistake, they'll transfer you to the other hotline, okay? So we're there to
Okay,
help.
here's a couple questions.
Yeah.
I recently took a listing and put a CBS code on my super lockbox and stated that I need the PEAD signed by the buyers and their agent before I will give them the CBS code. Is this legal?
It's legal as far as I know, unless it violates an MLS rule. I'm not the MLS rule expert, but I think that's legal. It's a good idea. You know what else is a good idea? Let's say you got a vacant property. How do you know when people are coming in there or not? How do you know they're following safe practices? So, I mean, it's almost like you need to limit the lockbox access. You need to limit it so that you can police, you know, you can't just have people going in and out because then they won't follow the rules and then you're not in compliance. And then you have no E&O coverage and then you don't have the potential lawsuits. So you really need to monitor access to your listings.
Do these rules apply to commercial properties as well?
Not specifically, but the CDC guidelines do. Remember, everywhere we go, all of us, we need to practice by law. You know, not every county requires a mask, but I think LA does, and I think Riverside does. But social distancing, the 6 feet apart, is everywhere. So yes, I would assume with my commercial property showings, even if they're not specifically under these rules, it's a really good idea to follow the same practices. But no, they're not specifically covered.
Okay. If a landlord wants to sell the property in June, can landlord give a 60-day notice to vacate property during this time?
Absolutely. Tenants, first, one question is, do tenants have to cooperate with showings? Yes. But remember what it says in LA, that means they got to leave before you show it. What if they won't leave? Well, then you're not supposed to show it. But that's a real problem, isn't it? That is a real problem. So you say to the tenant, if you don't leave, what can you do? Well, you can evict them, but remember what I said, right now you won't be able to do it till August anyway. All you can do really is threaten them, saying, you know, if you don't allow me to show this property, then you're interfering with our ability to sell. That may cost us money. It will cost us money. Prices may go down. It's going to cost buyers and sellers money because of what you're doing. So when we evict you, we're also going to sue you for all the damages that you're causing us. I mean, that's the only leverage you really have. Getting back to the question, yes, you can give them a 60-day notice today. You can give them a 30-day notice today if they've been there less than a year. But once those 60 days are over, what are you going to do? Well, I'll evict them. I hope they'll change that August 1st thing. But as of right now, the courts are saying we are not going to do any unlawful detainers until August 1st. So in that case, you send them the notice, but you're right, you send them in June, that takes you to August, so you should be good. But what I'm saying is you could even give them a 60-day notice today, but you may have a hard time evicting them when that notice is over. That's the problem.
Is it true that property managers cannot ask for proof of hardship when tenants cannot pay their rent?
No, that's not true. You can always ask for not only proof of hardship, you can ask for proof that it's a COVID-19 related hardship. I mean, something happened related to the virus. That's why they lost their job or whatever. Now, you can definitely demand proof of that unless, let me take that back, you're in a city. Some cities, I don't know if any cities out where you are, some cities have special rules like you don't have to show hardship. Some cities, remember I said they say you got 6 months or 8 months to pay the rent back. Some cities say landlords can't raise rent right now, even if you're not under rent control. So I'm answering the general state law is absolutely they have to provide proof. The only exception being depending on if you're in one of these cities that's more restrictive, and I don't think there are any of them out there where you are. I'm not sure.
Okay. Let's see what else we got here. Someone's asking to list all the forms you mentioned, but are they in zip forms?
They're in zip forms as of today. I can actually tell you what they are. There's the RLA CAA. Then there's that's the coronavirus addendum or amendment to the listing form. Then there's the PEAD and the PEAD LR. It's the property entry advisory and declaration. There's one for sales and there's one for rentals. Then there's the CVR, I'm sorry, the CVA, the Coronavirus Addendum, and the Coronavirus CVA-LR, that's for leases. Then there's the NUCC, Notice of Unforeseen Coronavirus Circumstance, and the NUCC-LR. So those three forms there's one for sales and rentals. The listing addendum is for both. You can use the same listing addendum for a lease listing or a regular listing. And then the last two are the NTAP, Notice to Tenant about payment of, Notice to Tenant about ability to pay rent. And then the last one is the RPD, the Rent Payment Delay. None of these are mandatory. The first two, though, the RLA CAA and the PEAD, the only reason I say they're sort of mandatory is because they embody the rules. So if you follow the rules and don't use the form, okay, fine. But the way to know for sure you're following the rules is you're using those forms that tell you what the rules are. And everybody who signs the forms is saying, yes, I'm following the rules. And that's what protects the realtor from getting sued, protects your E&O, protects liability, because your clients have committed themselves to follow the rules. And if they don't follow them and there's a problem, it's not on you. So they're not mandatory, but they're really important.
Okay. What options exist for landlords whose tenants can't pay their rent? Are there any government policies to reimburse them?
Well, good question. I mean, I know what you're thinking. These tenants are never going to pay it back. Well, I mean, they have to pay it back. There's nowhere that a tenant can say, I don't have to pay the rent back. There's a couple cities. If you're just not in a city with a special rule, they got to pay it back right away. They got to pay it back instantly. Some cities have put into law that they have 3 months, 6 months to pay it back, but they still got to pay it back. You may have heard there's a proposed law that is being proposed in Sacramento that we are fighting, and you're going to fight. We're probably going to ask you to do a red alert and everything that would say landlords have to forgive 25%, or they have to reduce the rent for their tenants by 25% in certain circumstances. We don't think it's going to pass. We're going to fight it very hard. So I don't think that's going to pass. So no. So there's no government program that's going to give you money to pay it back. I know what you're thinking. What if the tenant doesn't pay it back? And you're right. I mean, that's a problem, and it is a problem, but there's no particular government program for that.
Okay. The pandemic unemployment insurance that you talked about, I'm asking, a couple of people are asking, what was the date that you can apply for that again?
Next Tuesday, April 28th.
Okay.
And we are prepared for an onslaught of phone calls on April 28th. We're going to have a lot of people ready to answer the phone if you have questions on it. The good news is this is something they're not going to run out of money like they ran out of money for those SBA loans. It's just the delay in getting that money into your pockets. But it's retroactive too, back to January 27th. So if you're eligible for this, and if you've got any loss of income, you're going to be eligible. And I bet a lot of you have a loss of income compared to last year. You're going to be eligible. You're going to get the money, and it's going to be retroactive. So we're optimistic about that particular program.
Okay. We got a couple more here. Let's see. Due to cleaning supplies being unavailable, if a seller runs out of cleaning supplies, does this mean they can't show the property? Their home's not being able to adhere to the PEAD agreement.
Yeah, good question. You're right. It's part of the rules that seller has to clean and disinfect after each showing. Question is, what does that mean? Nobody knows exactly what that means. To me, if buyers are wearing gloves, wearing masks, and not touching anything and staying 6 feet apart, there's not a whole lot of cleaning that has to be done. Soap and water could be okay. And you really need to, in that circumstance, you clean the doorknob and any counters, anything that may have been touched or people put their purse down or something like that. It's not that extensive, and soap and water is sufficient. Hopefully there's still soap out there.
Do the eviction rules apply to commercial tenants?
No, but the unlawful detainer shutdown by the courts applies to commercial. So in other words, commercial don't have these eviction moratorium, commercial don't have these rules, they don't have to pay their rent, pay it back. But if a commercial tenant isn't performing and you want to evict them, the courts aren't going to process the unlawful detainer unless it's health and safety or security related. I guess if the tenant, residential or commercial, is a security risk, they've been committing illegal activities, yes, you could definitely evict them. Or, you know, it's one of these tenants who just totally doesn't clean up and the property itself has become sort of a health hazard, then you'll still be able to evict them. So health related and security related, you can still do unlawful detainers now. But for commercial, it's the same thing. The courts are not going to process an unlawful detainer even for commercial right now.
Okay, I got a couple questions about unemployment. I have a couple people asking me where they find the applications for unemployment. Do brokers qualify for PUA relief? And if a realtor has more than one job, can they collect unemployment on both?
See, this is where I'm so glad that I'm not the expert, which is why I direct you back to that phone number. The last part, yeah, I know, yes, even though you have another job, you might be able to get unemployment for that one and your lost income as a realtor. Well, you still have your other job, you could still get unemployment for your lost income. The applications, call that number. I don't think they're even available. I know they're not available yet. But anyway, that's why you call that number. Don't ask me, call the number, 213-351-8450. We're not getting many calls now at all. You'll get right through. Feel free to call.
Okay. And I think that's pretty much about it. The COVID relief website, that's the CAR website, right?
Well, it's a microsite. I mean, you could just,
I have it. I'll put the link in the chat.
CAR.org/coronavirus. But if you just go to your regular website, there's a link right there. So CAR.org/coronavirus.
Yeah, and we have it on our front page of our website as well.
Cool.
And then let's see. And I guess one last question. What is the website to check which city has the rule or not? Is that the CAR website or is there a different?
No, good question. If it's, remember I said there's two things. There's one sort of spreadsheet that shows what each city and county's rules are for showings and things like that. And that's on the special microsite. If you go to the front page of the CAR.org/coronavirus, on the right-hand side, there's a little checkbox that says local ordinances. Click that and you'll see. But as I said, Orange, San Bernardino, Riverside are all pretty much the same. And LA, I don't even think they've updated yet because it just happened Friday. Remember what I told you what LA is? You can do in-person showings of occupied properties, but the seller has to leave during the showing. Riverside, Orange, San Bernardino, you can just do it. But either way, it's still the rule of one agent, two buyers at a time, safe practices, et cetera. Now, if you're looking for the rules on each city's eviction moratorium, that's on the CAR website, just CAR.org. On the search bar, just type in eviction moratorium and you'll pull up that spreadsheet. So there's two different spreadsheets.
Okay. There's a point of clarification. You were talking about a realtor relief. Was it act or form?
There's no form, no act. I was saying there's a hotline. It's called the Realtor Relief Hotline.
Okay.
In other words, there's other things too. There's tax credits you may be eligible for. We're all supposed to get this tax rebate of $1,200. There are various programs out there, but the big three are the 2 SBA loans where they ran out of money, but you can still call the hotline. I can tell you about those. or the pandemic unemployment insurance, which opens up on 8 days from today, Tuesday the 28th. Those are the big three, and those are the ones they can help you with, tell you how to apply for it. And plus you want to decide which one is better for me. Is it one of these low interest loans with a $10,000 grant, or am I better just to do the unemployment? So that's what you'll have to figure out, but they can help you with that, and your own accountant can help you with that too.
Okay. Do you have time for one last question?
I got as much time as you want.
Okay. A tenant just passed away and her fiance is not on the contract, but still paying the rent on time. He only provide his passport, but keep delaying submit other personal info due to the latest loss and the COVID-19 issue. I guess they're asking what they should do now.
So was it COVID-19 related? Is that what they're saying?
It doesn't, maybe.
Yeah, I mean, normally if just a tenant passes away and there's one person still there, but they're not on the lease, you can evict that person if you want to. If they're on the lease, then we got this new, if they've been there 12 months, you can't evict in California unless it's a single family or new construction. But if it's COVID-19, if the question is, what if the one who died of COVID-19, what's that issue? Well, that's just a disclosure issue. If you re-rent the property, or if you evict the one who's there and then you want to re-rent it, you'd have to disclose that the previous tenant passed away because of COVID-19.
Okay.
Yeah.
Would you suggest as a best practice to have, like, if you have a vendor going into a unit to sign a PEAD?
I wouldn't just say it's best practice. It's basically required.
Okay.
The CDC guidelines that the governor adopted in the state order encompasses that anyone who enters the property should follow safe practices and declare that they're not sick and haven't had contact. So the best way to make that happen is you sign the PAD, which means they promise to follow the safe practices. They promise to assume the risk, and that's where they declare about their issue. That's why, remember, we did this form to help you comply with the law, and it does apply to vendors, inspectors, anybody who enters the property.
Great. I think that's about it. Mary, do you have anything? Any questions?
I have a question. No, that was great. Thanks, Bev. That was really, really informative. And
My pleasure.
So we'll have this presentation on our website. I know many people are asking about that. We'll have it on the website, tricorealtors.com, under the education tab. It'll go up probably in the next couple of days, so keep an eye out for that. And also, Jordan did send me his slides from earlier, and I'll put those on the website as well.
Great.
Okay?
I think that does it. So,
Yeah.
All right.
Thank you for your time, Gov.
My pleasure. See you soon.
Okay.
Everybody
Bye-bye.
healthy, stay safe.
You too.